Welcome to the Interesting Lawyers Podcast. I'd like to introduce you to Adam Kemper.
Thanks
Good morning.
for having me.
And thank you for joining me. It's always a better experience to have guests here in the studio so I can grill them in person. Look, I know you're a labor and employment lawyer. I know you used to work for a big firm, and now you have your own firm, the workplace law firm. When it comes to employers and employees, you're on the employer's side of the equation, right?
Correct.
You're the one who works for employers, and you give people advice about how not to get sued.
That's correct. In 15 plus years of practicing law, I've seen the expense, the stress, the business disruption that's involved anytime a business is being sued, and then they just lose sight of how this is all correctable.
And just from living my life and dealing with a lot of firms, I see a lot of things that I know are actionable that people can get sued for. Mm-hmm. It's a target-rich environment for plaintiffs, if you will,
Sure.
In terms of lawsuits, just to be clear. But you're the guy who tries to head that off at the pass, and you do advice work for companies, correct?
Correct.
I've brought you on today because there's a lot of hot issues in the labor and employment field. They've always been there in one way or another.
There's
but
always hot issues.
they always rear their ugly head. The first thing I'd like to talk to you about is the perilous world of nannies. Now, I've seen many headlines over the years about celebrities who get in trouble because of their nannies. Talk about that.
This has become the real world example that I think a lot of people can relate to, because a lot of people have household employees and they just assume that they don't need to have any formalities in place. But the reality is you have to treat your household like it's a business. You have to set up an entity. You have to pay these people like they're employees. Maybe you want to get the insurance like you would, just in case the nanny slips and falls or decides that nanny is not being treated properly. So maybe you want to get insurance for that. And then you want to pay these nannies minimum wage and overtime.
But look, let's face it. Aren't nannies some of the most important and closest people that anyone can have working for them? These are people who you entrust your children with. It's not just about cleaning the house or walking the dogs. It's picking the kids up at school, dropping them off at school, doing things that you can't do because you're busy.
And a lot of these nannies are, not only do they not receive proper payment of wages, but a lot of them are mistreated by the household owners, because it's like these household owners don't feel like they're real employees to them, which is a total misconception, and it's really just not the right way to do things.
But aren't a lot of nannies here illegally? They don't even have immigration status?
Some are not, but that brings up another good point. So anytime you employ somebody, they also have to be legally authorized to work here in the U.S.
Look, I know that you represent employers. I know that you give great advice. I hold you in very high regard. Otherwise, you would not be sitting here. I'd have some other guy here. But I know the way people are supposed to do things. But let's talk about reality. Mm-hmm. And let's start with people who have tons of money who still screw it up, celebrities. Can you give us a couple of examples of celebrities who have been in the news for mistreating or not handling their nannies right, and what the consequences have been?
Most notably, we've seen Mariah Carey, we've seen Nick Cannon. Of course, P. Diddy has made his rounds for a number of reasons, including his treatment of household workers. We've seen Alanis Morissette. The list goes on, really. If you just do a simple Google search for nanny celebrity lawsuit, you're going to see how rampant this issue is. And it's not just unpaid minimum wage, unpaid overtime. It's really like the allegations are very abusive behavior. And it really paints the celebrities in a bad way, because if that's how celebrities are allegedly treating their household employees, then it's like, how are they treating everybody else? And should these be celebrities that we should be looking up to?
Well, first of all, why are they like that? These people have more money than God. They could be as nice or as mean as they want. What drives it? Why celebrities? Why are they always getting in the news about that, aside from the fact that they're celebrities?
I think it's twofold. I think, one, there is legitimacy to some of this, okay? I do think that celebrities, like many business owners, simply do not understand their legal obligations, okay? So I think that's part of it. It's a little bit of ignorance. And then there's a little bit of exploitation going on as well. It's in defense of the celebrities. Anytime you bring somebody into an environment where they're working for somebody with a lot of wealth, some of them think, how can I take advantage of this situation? And maybe just make up a fact pattern that suits me in the moment and that makes the celebrity look awfully bad. And I think there's some of that going on as well.
I know that nannies have also become the fly in the ointment, so to speak, for people seeking political office or other things where all of a sudden they're out of the running. They drop out or they're terminated or something adverse happens to someone, and it all goes back not to their billions of dollars of wealth or their business dealings or the degree of success they've had, but because of an issue with their nanny. Tell us a couple of quick examples of that, please.
I think you made a good point earlier as far as the nannies having access to a high level of information because they're in the household. So they're learning a lot about the dynamics of celebrities, politicians, high wealth earners, etc. And a lot of them will be asked to sign NDAs, of course,
Right.
to protect all of that information from being disclosed. But what's to say a nanny just feels like rolling the dice and disregarding the NDA and just saying, you know what, I think it's more advantageous for me to potentially disregard a non-disclosure agreement, even if I get sued for it, because I want to come out with my story and maybe make more money about it. I think there's certainly those dynamics at play.
Is it just about the money, though? If there's a nanny out there who is getting verbally and maybe even physically abused by the person they're working for, but they've signed this non-disclosure agreement, is that generally going to stop them from going to a lawyer or bringing a lawsuit or not?
Yeah, I think that the nanny will evaluate his or her options with his or her attorney. And some nannies have higher aspirations than others. Many want to maybe publicize their events and become famous because of it. So they want to talk about it. And they see the value of that as being higher than whatever maybe the payout was involved in, like a settlement agreement or some type of non-disclosure. So they're evaluating their options just like any one of us. And some of them, like I said, have higher aspirations than others.
Sounds like a great answer to give to a company that may be facing a potential claim. But what about just doing the right thing? Aren't there some nannies out there who would file a lawsuit or make a claim just because of the fact that they were mistreated, they were wronged, and now they've realized that and probably been impacted by it? Aside from any motive to embarrass or to make money, aren't there also people like that, in fairness? I ask you that on behalf of nannies everywhere.
Of course. Yeah, look, with every set of bad facts, there are some good fact patterns. There are some liabilities there as well. So, yeah, certainly there are legitimate claims that go along with the illegitimate claims that we see.
So for all of our listeners out there who have nannies or have the wherewithal or ability to get a nanny, what should those people do in advance?
Okay. Number one, they should treat their household like a business. We set up an entity that sort of manages the household operation because we're treating it like a business. And number two is you set up payroll, just like you would a small business, and you begin to keep time for these employees and you pay them minimum wage and you pay them overtime. Number three, you get the appropriate insurances in place, just in case there's a slip and fall, just in case there's an injury, so that you protect yourself and that you have this insurance policy to protect you. The last thing you want is to be on the hook personally for a claim brought by your nanny and to have this exposure when all of these things are very correctable. These are easy fixes. It's just a lot of people, they don't even know that they have to have these formalities in place for something like a household worker. But the reality is they do. So make the fixes now, avoid the headaches later.
What are the 3 easiest ways to get sued by your nanny?
3 easiest ways are, number one, if you're not paying the nanny at least minimum wage. Okay, number two is you're not paying them overtime. And then number three, you cause some harm to the nanny, either intentionally or negligently, meaning your house is not a safe place and the nanny slips and falls and becomes injured and you didn't have the proper insurance in place. Those are 3 very easy, everyday ways for your nanny to sue you.
Let me move on to Title VII, federal law that protects people against discrimination, typically race-based discrimination, and of course sexual harassment.
Mm-hmm. I'm talking about it every day because it's an everyday topic that companies should be thinking about, because we all, innate in us, have some level of unconscious bias, right? But we don't want that coming out in the way of a potential discriminatory hiring or firing or payment practice. So we have to be more mindful as to how we're treating our employees on an everyday basis, from inception, meaning the hiring phase, to the termination phase. And if something looks like it's being done as a result of one of these protected classes, that could be a cause for a lawsuit.
Let's get real. There is prejudice out there still.
Sure.
Deep, dark secret. People don't talk about it. Do you come across a lot of companies that, not necessarily at the highest levels of management, but that they have people working for them who have some racial prejudice, who take actions that they should not take on that basis?
Absolutely.
How prevalent is that?
It's more prevalent than is comfortable knowing, if that makes sense.
What does that mean?
That means that a lot of the racism and discrimination happens in everyday workplaces, to the point where we feel like, have we really made that much progress since 1964? And what do I mean by that? I think what people bring to the workplace is the same prejudices that they have at home. So if they're prejudiced behind the scenes, maybe they're not outright saying these things, like using prejudicial terms, but they're acting in accord with their prejudices and these unconscious biases. So it makes its way into a lot of workplaces. And what does a company have to do to avoid being sued?
That's why they have you.
That's partly why they have me.
Right.
Number one, they acknowledge that it exists. Okay, we don't put our heads in the sand. Okay, we acknowledge that these are human beings, that they bring these issues into the workplace. So what do we do about it? Number one, we make sure we have a policy in place that says, if you feel like you're being discriminated against, or if you're observing someone who is being discriminated against, you need to report it. You need to do something about it. Because we as an employer, we can't do anything about it unless we know about it.
Let me stop you there. How many employers actually do that? Just in the overall landscape of employers. I'm sure all of your clients do it because you kick their ass if they don't, right?
My clients do it.
Okay.
But they can still get in trouble.
I know, but first of all, are there a lot of companies that don't even have a policy like that?
Yes.
Okay.
Yes.
So you've heard the old saying, he or she who lives by the sword dies by the sword. Is that, do you think, one of the things that holds some people back from instituting policies like that, that it might get shoved up their ass by an employee when they violate it?
Yeah, they need to know that they need to have this in place, and that's part of what I do for companies.
What better location to be having this conversation than Boca Raton, Florida? Because I'm sure you're aware that in Boca Raton, Florida, because of the way some lifeguards were treated or mistreated, depending on your perspective,
yeah.
The United States Supreme Court in the Farragher versus City of Boca Raton case held that employers must have a well-defined and well-disseminated anti-discrimination and anti-harassment policy. In other words, it's one thing to have a policy, it's another to make sure that your employees know about it.
Correct.
So that they can live by it and you can live by it.
And actually, my first employer out of law school was Bill Amlong, who represented Beth Ann Farragher before the Supreme Court in that case.
I remember the Amlongs, very good, very smart people, very aggressive labor and employment lawyers. I didn't know you worked for them.
Yeah, so I'm very familiar with that case. And it's not only like a textbook sexual harassment case, it's a textbook reason for companies to institute these policies, because now if they have the policies and the employees know about them, and let's say they don't follow that policy, now you have what's called the Farragher affirmative defense.
What did the city of Boca Raton do to get themselves into that pickle?
So we have a female lifeguard working on the beach, having a bunch of male lifeguards sexually harassing her. And Beth Ann reported it, and basically the city didn't do anything, and she decided to sue for sexual harassment. And one of the defenses that the city raised is that, well, we didn't know about all of this because maybe you didn't report it up the proper channels. But part of the issue is they didn't have that mechanism in place for her to report it up the proper channels for them to be in a position to do something about it. Now, when we look at that case and we look at any sexual harassment case or any harassment case for that meaning, we look at what is the employer doing to prevent it? Yeah, what is the employer doing to prevent it? And does the employer have a policy in place that its employees know about? Are they receiving training on it? Are they acknowledging that they attended the training? And are they utilizing it? And that's why the facts of Beth Ann Farragher in that case are so important to the modern day context of the workplace.
So in that case, the city, the employer actually had a policy, but they were claiming we didn't know about it. No one told us. We didn't know. That was their main defense?
That was the issue,
And
yeah.
what happened? Did the lifeguard get...
She won. I had a similar case that, if you'd like me to share.
Of course.
Okay. While I was with the Amlong firm, and this is a plaintiff's firm that specializes in employment law, a case that I worked on was Melissa Smith v. City of New Smyrna Beach. And this is a female firefighter. Okay. Now we have a firefighter, the only female there. There was no women's restrooms because they'd never had a female before. So she had to change in front of other men. And she was harassed on a daily basis. Another very egregious fact pattern. Was told she can't bring her tampons into the firehouse. No women magazines. Come sit on my lap. Grabbing of body parts. You name it. Textbook sexual harassment case. That was the last case that I worked on at the Amlong firm before I switched over to the dark side, defense side. And the City of New Smyrna Beach fought tooth and nail in that case.
Go back to reality for a minute.
Okay.
In workplaces, when people work together closely, whether they're men, women, regardless of race or any of those other factors, people get chummy, right? People's personalities come out. I'm very sarcastic. I make all kinds of outrageous jokes just in an effort to be funny. A lot of that goes on, right?
Sure.
And a lot of times the conversation will drift into a sexual nature with absolutely no ill will or anything like that. And of course, things can be taken the wrong way. Or it could be encouraged just because of the atmosphere and everyone knows everyone else and they're all friends and all of that. Don't things like that sometimes get flipped on their head and used against the employer when the employee is terminated or if they bring a sexual harassment claim? Talk about that. In other words, when human nature meets employment law, what's the rub?
Yeah. To your point, people spend a lot of time in their workplaces, right? People spend most of their waking hours in their own workplace, if you think about it. So when you're spending that much time in the workplace, it's possible, it's probable in certain instances for you to develop relationships. And some of those are romantic, and some of those are a consensual relationship, and some of those are not romantic, but could be like the harassing kind. And as an employer, you have an obligation to protect against the harassing kind, not the consensual one, because the consensual one is consensual by nature. So, yes, at the time an employee's let go, what they'll often do, especially in this day and age where you can Google that I've been wrongfully terminated, and you'll have 15 plaintiff's lawyers ready to talk to you and take your case right on the spot without even really understanding the facts. Okay? So you talk to one of these lawyers that do the ads on Google. You know the ones I'm talking about.
Sure.
And the lawyer starts talking to the person and starts basically building the case for the plaintiff. And maybe he or she didn't even know that they had a case until they met with the lawyer.
But that surely that doesn't matter to you, does it? No, if someone's not aware of their rights and a lawyer makes them aware, that doesn't make their case any less legitimate.
That's true. More often what I see out of this fact pattern that I'm talking about is that maybe the plaintiff's lawyer doesn't see that there's a wrongful termination type case, but that the company screwed up on wage and hour. And that's like the secondary issue that the lawyer finds during that consultation.
Let me make sure I understand what you've told us. Regardless of what the problem is that someone's having in their workplace, there's always that separate issue of, you call it wage and hour, I call it overtime, where they're working more than 40 hours a week and they're not getting time and a half for all hours worked over 40. Yeah. I don't want to say that's a fallback, but that's always a separate independent option, regardless of anything else. Correct?
Yeah.
Let's talk a little more about workplace relationships between people in the workplace. First of all, are they inherently difficult or problematic, in your opinion, as a lawyer who advises employers?
I work with my wife. A lot of people work with their spouses, so they can work just fine. But to your point, there is a rub there, because what happens when that relationship ends? Oftentimes, I see sexual harassment cases arising out of a relationship which ended, but one side continued to pursue the other side, and it was no longer consensual. Yes, that's a situation where it can be problematic. Here's another situation: the optics of a relationship. Let's say you have a supervisor managing a subordinate employee and they're in a relationship. Optics alone is going to give other employees the feeling like there's some favoritism involved. And favoritism is just another word for discrimination.
What's your advice to companies who come to you with situations like that? What should they do?
Have a policy which requires the employees to disclose the existence of their romantic relationship and to put the onus on the company to evaluate, is this a conflict? Is this going to be a problem, even by optics alone?
Is that what you tell these employers?
Yeah. And then when that relationship ends, if it ends, hopefully it doesn't, but many of these relationships do end. Okay, some of them do in divorce. We know the statistics around that. You need to let us know, because at that time, we may need to take further action to protect our interests as a company. And that could include separating the two.
It's amazing to me that we are discussing labor law on the corporate level involving employers, and we're talking about issues that have to do with what is normally very private, very discreet, none of anyone's business, a romantic, intimate, sometimes sexual relationship between people on polar opposites. But the two of these things come together and they merge, and they usually land on the desk of someone like you for the employer and someone who might advertise on the internet for employees, right?
Yeah, you have to see the issue. That's the problem with a lot of companies, is they don't even think this is an issue.
And that's what makes a horse race, as they say, isn't it?
Yeah, exactly.
All right. Now, Adam, can you talk about a few situations in workplaces that are pretty common that are sexual harassment versus others that are not? Okay, that those gray line situations. Can you give 3 or 4 examples of that for our listeners?
Yeah, absolutely. The first one would be, like I said, the consensual relationship, where maybe at the end of that relationship, one side decided to continue to pursue the other. Okay? After the relationship ends, there's no longer consent there. So if one side is continuing to pursue the other side to the point where it's interfering with the job, and it's a pretty high standard coming from the defense side. It's a high standard to prove actual sexual harassment. That could be a situation where where it's like the harassment continues and someone just can't concentrate, can't perform their job because this other person is continuing to pursue. The other one is the classic quid pro quo, which means I will give you this job, employer, in exchange for you giving me some sexual act. As blunt as that sounds, it's not as commonplace as the other one, but it still happens.
It's outrageous.
Where it's, you want this promotion, you want this job, what are you going to do for it? That's quid pro quo. So that's a more viable sexual harassment claim than the other one, which is a little bit more difficult to prove. It's called the hostile work environment claim, and I'm sure you've heard people use the term hostile work environment, which in many people's own opinions is a situation where they're being held accountable to their job, which would not qualify as harassment, or where they just have a mean boss that yells or raises their voice. That's not necessarily a hostile work environment. That's somebody who's yelling and raising their voice, which happens in workplaces all across the country. The situations where you would not see a viable harassment claim are those which I'm talking about, which is a situation where maybe you have an equal opportunity harasser, someone who harasses everybody equally. This is, believe it or not, a legal defense. They're just a jerk to everybody. So it's not like this person is treating someone differently because of a protected characteristic. So that's one. The other one is the normal things that happen in every workplace is that maybe super sensitive person, the super sensitive Steve or Sally, just can't handle being held accountable to his or her job. and calls that a hostile work environment and says, I'm going to sue for this. This is ridiculous. You told me what I needed to do for my job. You wrote me up when I didn't do what I was supposed to do. And you can see how I feel about that. It's just, it happens every day where people complain about these things that happen in every workplace in the country. That is not a true harassment claim. That is what's called doing your job and being held accountable.
How effective can you really be, given human nature and the people who you have to deal with?
Look, what I'll tell every business is just because this won't expose you doesn't mean you shouldn't do something about it. Meaning, a equal opportunity harasser shouldn't be in your workplace.
Yeah, but even if it's an equal opportunity harasser, if that person or that company creates a sexually charged atmosphere, that can be the basis for a hostile work environment claimed by that employee, correct?
Yeah. If it's aimed at someone because of their sex, not because they're just an equal opportunity jerk. So if they're treating, let's say it's a male, treating women only a certain way and maybe only harassing women, and it interferes with their job performance, that could be a true hostile work environment claim.
When it comes to LGBTQ issues, which of course are a very hot topic right now in this political and election season, what are the most common, let's say the three most common situations involving LGBTQ employers or employees and where things can go sideways in an employment context?
So what I've seen is the issue involving someone who wants to be recognized a certain way by their gender identity and use of certain pronouns, and maybe someone who has a religious reason to objecting to calling someone by certain pronouns. I've seen that dynamic take headway. And can you imagine the conflict there? Because people with sexual orientation or gender identity, they have the same legal protections as someone with a religious observation. So that is really like a pretty significant issue that you have to deal with. So what do? You try and find a compromise. And a lot of this is not even legal. It's just like human relations. Like, how can we deal with making both of you at least a little less unhappy? Maybe it's not totally happy. It's like going to mediation. You try to walk away just a little unhappy, but you find a compromise. So that's what we do in a situation like that. So we find a compromise. Maybe we split the two up. We ask the two that they be respectful for one another. And if one of them crosses the line, I'm going to recommend disciplinary action. But I'm not going to tell an employer to pick one side over the other, because that's where there can be problems.
Are there specific policies that you recommend to employers regarding LGBTQ issues, employees, sensitivities, and whatnot?
The same types of things for any form of discrimination. Just because it's the hot issue now, you don't want to show extra attention or additional attention to one protected characteristic over the other, because then it's, what about all of us? Why are we spending all this time talking about gender identity and LGBTQ and all of this when the rest of us are still here and we all have our own rights and protections? And then it's like you're indirectly discriminating against other people. So consistency is like the best defense to all of this. Be consistent.
Just as a follow-up on the hostile workplace claims, I was about to say, is it your testimony that, but this is not a deposition.
That's the trial lawyer in you.
Thank you. It's like a zebra and stripes situation. Tough to wash them off.
I get it.
But it's helpful when I'm interrogating people like you. I say that jokingly for those who are listening and can't see me smiling. But are you telling us that if a company has a supervisor who basically hates everyone, he hates men, hates women, hates people of every orientation, all races, is an equal opportunity hater, and that supervisor spews obscenities, inappropriate things, tells jokes that are racially inappropriate, sexually inappropriate, but does it for everybody? Are you saying that it's okay to have a supervisor like that? Are you going to advise your client that it's okay as long as they don't single anyone out?
Of course not. Of course not. I'm going because there's more to this than will we have a legal defense if we're challenged on this? Okay. It's what are best practices? And if you had one bad apple, that can taint the whole orchard, right? And if that apple sits there long enough, it's going to rot the entire field. We have to identify that and eliminate that, even if it's a top performing employee, because that's one of the issues I get all the time from my clients is, Adam, this person makes us a boatload of money, even though he or she is rough around the edges. That's how they try and defend it. So I hear that all the time. And I say, that's fine. But what about the revolving door of employees that are leaving and coming and going because of this one employee? Are you not thinking about that? Okay. What about maybe you don't get the lawsuit, but maybe you get the Indeed.com or the Career Builder review, which says, this is a terrible working environment because of so-and-so, and they just continue to keep this person. And then you lose candidates who see that. What about the impact of that?
I was thinking about Glassdoor, which I know is another one of those sites where people can analyze or compliment or criticize, more often than not, their employer and usually their former employer. So have you learned things about your own clients over the years from things like Glassdoor reviews that come out, and that's how the issue comes up?
I've often said that if you give employees a forum to complain, they will complain. Okay, so you have to take that with a grain of salt, some of those reviews. People are not always going to leave glowing reviews about their experience, whether it is dining at a restaurant or working for a company. You tend to only see the people who are willing to spend their own time writing something when it was a negative experience. So we have to keep that in mind. But if you start seeing the same type of thing over and over, they keep Joe around too long and Joe's just a jerk to everybody, and then you see 5 or 6 of those reviews in a row, and the company's just, Joe is making us so much money. They're not, when I see something like that, they're very short-sighted, okay? The company's being very short-sighted, is not thinking about all of the repercussions that I just talked about, including the impact to future candidates. So we have to hang that in the balance and make a cost-benefit analysis. And is it really worth it to keep Joe around when you have all these reviews in place and maybe you're not knowing about the people who are choosing not to apply for your business because of that? But at some point, people are going to look at this and say, you know what, I'd rather just go elsewhere. I don't want to deal with Joe.
So during my decades of practice, a lot of people came to me, and I just felt that they fell into what's called the unwritten 20-40-60 rule, which is if you've been with the company over 20 years and you make over $40,000 a year and you're over 60 years old, you are a target for replacement or termination. First of all, have you heard of that before?
Just now.
Okay. Is there anything to that in the eyes of the law? If someone is terminated because of the 20-40-60 rule and they can prove it, do they have a case?
If I saw a piece of paper with a 20-40-60 rule being exchanged with my executives for my business that I'm representing, I would say that's a problem.
That's a no-brainer because you're talking about if there's a smoking gun. But what if there's a company and they've terminated 5 people or 10 people who happen to meet the 20-40-60 rule? Okay, and now the 6th person is terminated who falls under that rule as well. Is history any guide? Does that carry any weight in terms of age discrimination?
Yeah, now you have a pattern in practice.
Talk to us about that.
Okay, I don't want to get too granular with this, but there's 2 ways to allege discrimination. One is called disparate treatment, one is called disparate impact, okay? Disparate treatment is like the one-off scenario where someone's individually feeling like they've been discharged for a protected reason. Disparate impact is like when there's like this study, this pattern and practice of a policy affecting one particular group of people, like what you just described. So this would probably fall under the disparate impact theory.
If there's a pattern, that's a problem for an employer.
That's just ridiculous. Why wouldn't you evaluate someone on their qualifications for the position rather than simply just meeting the age criteria and, let's say, the salary criteria? Having said that, companies often get challenged on financially backed decisions. And so if a company does, let's say, a group layoff, and they're forced to lay off a bunch of people, and coincidentally, a lot of those people just happen to be older because they happen to be the high wage earners. Okay, maybe there's Those coincide there. And if you replace those high wage earners with lower wage earners that coincidentally are younger, that may look like a disparate impact, but really it's a financially backed decision, which would be a legal defense.
And that's not age-based discrimination.
That's
It's
financial.
always cheaper to hire new people who are just starting out in their careers, right, than to pay older people who have been there for a long time.
It needs to make sense, though. Okay, so if you,
But that makes it okay and legal to do that?
if you're making your decision for financial reasons, okay, not age, financial. Every company in America makes cutting decisions for financial reasons. Now, will you be challenged on this? Yeah, of course, you're more likely to be challenged on this. And do companies want to deal with defending their position? So here's the other thing. It's like a lot of what we talk about is like what will happen in a court of law and will you have a legal defense? A lot of companies just don't even want to be sued, okay, because then they have to defend their position. And we all know through the press that even the accusation of your being sued is not good press, even if you ultimately win. And we all know that in employment law, you don't win a case, you just don't lose a case. Does that make sense?
Sure.
Okay, because you don't get anything at the end of it. In an employment case, if you defend a case through trial and you win, there's not like a pot of gold waiting for you. It's, okay, I just don't have to pay a bunch of money, but I just paid my lawyer a few $100,000 to defend me all the way through this. There's no reward at the end of it. My goal with my practice is to avoid that whole scenario. I don't want my clients being sued. I don't want them going through that process. I know how expensive, stressful, and disruptive being sued is in general. And I know that the press and the repercussions and how human behavior, how we all react to just a company being sued, even if they technically didn't do anything wrong, I know how people react to that.
Do you agree that the vast majority of companies that get sued in cases that have some legitimacy, in those cases, the employer's wounds are self-inflicted, brought upon themselves?
Yeah, I do think, to the point I mentioned earlier, a lot of this can be corrected.
Yeah, but just like the people who are on one side or the other of the whatever harassment or improper actions being taken, we're dealing with human beings and their judgment and also their genetics, right? Mm-hmm. I've always felt that as long as men and women work together in the workplace, sexual harassment will always be at least an issue, whether it's happening or not. You agree?
Yeah.
Which calls the question, what about AI? So, Adam, where do you see the state of affairs 5 years from now, which is like 100 years in technology terms, with AI? Shouldn't AI be handling issues like this, making decisions based on data specific to a company and also on a more macro basis to a whole industry? Isn't AI capable of making better and more accurate and defensible decisions in employment matters because it takes out of it the human judgment part of it? Because as humans, as we are all imperfect.
Yeah, I think AI is going through a state now where we're all experiencing the trial and error of it. I think we're still in the very early stages of it. So there are some flaws with relying on AI, and we're seeing a lot of that take shape now. I think the goal for humanity over these next 5 years is to find a home for AI. Okay, because I don't think AI is the be-all, end-all, my personal opinion. I think it'll have a place to supplement us. Let's keep that in mind. It's a tool. We need to understand how to properly use that tool while still offering our own expertise. In my opinion, AI, I don't think will ever replace any consulting-based practices because people come to us for our brain and our experience and everything that we've gone through.
And I thank you for that as a consultant myself.
Exactly. So we can relate. We do a lot of consulting work together.
But do you think AI is going to play a much bigger role in everything from hiring decisions to background checks to management of ongoing disputes and enforcement of policies against both employees and employers?
It may be sooner. It may be later. We need to have AI make enough mistakes for us to be able to properly craft its use in the hiring process. Because right now, there's a lot of EEOC guidance on some of the biases that are built into some of this AI software. let's say AI just for a certain company just happens to pick out all the men or all the white Caucasian males under 40. That's a problem. And employer just can't say, hey, we relied on AI. We shouldn't be at fault for this. No, you're still the employer. So we have to see it through its trial and error, and we have to see it through it to make its mistakes, to be able to perfect it, and then rely on it as a tool. We're not there yet. It may be 5 years, it may be 10 years, it may be 3 years.
But we'll still have jobs, you and me, right?
You and I will still have jobs. I do think there will be, once we figure out that tool and the best use case for AI, that could replace certain jobs. It could.
I think the best way to put it is that AI is not going to replace you, but people who know how to use AI are going to replace you. Some people, their jobs will be wiped out, but a lot of other people, they're still going to be employable if they know how to leverage AI and use it to produce even better results. But you still need that human element, because that's certain. At the end of the day, I think that certain discretion, that certain judgment, that certain feeling, that visceral feeling you get, that's not going to happen with AI probably for at least 10 years when it becomes sentient. And then who knows? For anyone who wants to reach you, tell them how they can do that.
Sure. So I'm very active on LinkedIn, so definitely connect with me on LinkedIn. I post just about every day free content so that you can learn more about employment law and best practices for HR. You can also find me on my website, www.theworkplacelawfirm.com, and you'll have all my contact information there.
Adam Kemper, employment and labor lawyer extraordinaire, thank you so much for coming on today. We have a lot more to talk about, so in the future, I'd like you to come back, either individually or as part of a panel. I'm going to start getting some panels together so that they can slug it out while I watch and eat popcorn.
Sounds great.
And that's the end of today's episode. Thank you very much for tuning in, and we'll see you next time.